An apple a day keeps the doctor away, but a glass of OJ keeps the adversary at bay. Here's Oddjob.
Hey, it's time for a glass of OJ. This is Oddjob. This is going to be a very different video than all of you are used to. This is going to be about 36 or so minutes long. I know because I've rehearsed it, and it's scripted. One of the few times I'm going to ever script my my videos. Usually what I do is I write some key points that I want to do, I want to talk about and discuss, and you'll see me glancing sometimes at the screen. That's because that's my little outline to know what points to move on to. And for this one, I've written out an entire script, and it's because we're going to be talking about the Hadnagy versus Jeff Moss DEF-CON lawsuit that's ongoing right now. And so I want to do this because this is something that I care about. It's about the community. It's about conferences. I think a lot of us are interested in going to conferences. Code of conducts mean a lot to us. And I've worked to help make sure conferences I've been to or organized have good codes of conduct and that they're defensible. I also want to write a script because there's a lot of facts here, and they need to be stated exactly how they are written. And there's claims that are being made, and they need to be characterized the way they are asserted. And so I want to make sure I stick to those facts, and I don't opine too much about what I think or speculation that I think is really going on. This video is about the facts that exist, the facts that we have access to, via the court filings and via public statements that are made by both parties, and really nothing else. So now begins the script. This is not competent legal analysis. I am not a lawyer. None of my statements here should be construed to be, nor are any of my statements here intended to be legal advice. If you get your legal advice from a random dude on YouTube, you're a moron. This analysis is going to be about the facts as they are substantiated or alleged in the case files, and what is publicly available via statements on the internet by either party or parties talking about the issue. I am not going to offer my opinion as to Hadnagy as a person or DEF-CON as an organization, nor am I going to accuse him or DEF-CON of any wrongdoing here. I'm going to analyze the court records we have so far and make some speculations as to what might happen in the future and potential consequences I foresee if it turns out one party or the other are incorrect in their statements they have made in their filings. To be certain, both parties cannot be telling the truth in their statements they've made so far. One of them is correct in whole or in part, or the other is correct in whole or in part. And we'll get to that as we look at the case. So a bit of background. Chris Hadnagy ran a village at DEF-CON under the name SE Village. It was run by his company, Social Engineer LLC. DEF-CON has a code of conduct policy that prohibits many actions, and they enforce the code of conduct via many options, including banning an attendee or participant from the conference. On February 9th, 2022, DEF-CON posted a Code of Conduct Transparency report to their website. In that report, it stated this among other items that pertain to other people. We received multiple violation reports about a DEF-CON village leader, Chris Hadnagy, of the SE Village. After conversations with the reporting parties and Chris, we are confident the severity of the transgressions merits a ban from DEF-CON, end quote. Hadnagy on February 25th, 2022, released a statement to deny allegations and even indicate he has no idea as to the context of any allegations which led to his banning. Quote, "The problem I have is that I still don't know what the accusations are. In the DEF-CON transparency statement, Jeff Moss stated that he spoke with me about the situation. He did not. We exchanged numerous DMs and emails. In none of those communications did he ever outline the accusations. He made his decision without actually speaking with me," end quote. Hadnagy also indicated that he has no desire for the accuser's identity to be made public. Quote, Others have assumed that I want to know who the accusers are. I have no desire for the accuser's identity to be made public. I understand the sensitivity of that information, and I would like this to do the same, and I would do the same regarding protecting their identity, end quote. Hadnagy also indicated that he identified speculation on social media about the possible reasons for the ban. Quote, much of the speculation on social media seems to assume sexual misconduct. While I still have not heard the exact allegations, a person closely affiliated with the DEF CON has informed me that the allegations are not related to sexual misconduct, end quote. The complaint. On August 3rd, 2022, Hadnagy filed a federal suit against DEF CON as well as Jeff Moss individually in the United States District Court of Eastern Pennsylvania, likely because this is where Hadnagy and Social Engineer LLC are located. In the complaint, Chris asserts the following amongst many other things we're not going to address in this video. One thing, first of all, that I really like about court cases, especially in complaints, is that every paragraph or every sentence pretty much has a number next to it. So you can go sentence by sentence or, paragraph by paragraph. I am starting at paragraph 44. And you can see links to all of the statements and the court proceedings or the court records in the doobly-doo. So please do check on those. We are in the initial complaint that Chris Hadnagy filed on August 3rd, 2022. In quote, on paragraph 44, quote, in August of 2020, due to the COVID-19 pandemic, the event itself was canceled and virtualized. Nevertheless, DEF CON Safe Mode, a virtual event, was held and offered a full roster of speakers, villages, contests, etc. However, in August of 2021, the event was held in person in Las Vegas once again. Plaintiffs chose not to participate. Plaintiffs in this case, by the way, just so you know, plaintiffs in this case means Chris Hadnagy and Social Engineer LLC. Defendants in this case mean Jeff Moss and DEF CON. So back to it. Let's go back to paragraph 46. Plaintiffs chose not to participate in the event in August of 2021. Around that same time period, defendant Moss and plaintiff Hadnagy agreed to discuss plaintiff's contribution to future events. However, that discussion never actually happened. Then suddenly, without warning, in or around January of 2022, defendants informed plaintiff Hadnagy that neither he nor plaintiff Social Engineer could attend, contribute to, or participate at the event going forward. This ban on plaintiff's attendance, contribution, and participation was based on alleged violations of defendant DEF CON's code of conduct and effectively excluding plaintiffs from the event indefinitely. Plaintiffs denied and continued to deny any violations of the code of conduct at any point in time. Plaintiff Hadnagy had made repeated requests for additional detailed information regarding the alleged violations. His requests were ignored time and again. Defendants provided no evidentiary support or explanation regarding their abrupt termination of plaintiff's attendance, contribution, and participation at the event. It is believed and therefore averred. Averred is a fancy legal word for asserted. Averred that defendant Moss, individually and acting on behalf of defendant DEF CON, with knowledge and intent falsely alleged that plaintiffs violated the code of conduct in order to replace plaintiff's SE village with another village targeted to similar topics but organized and hosted by others. That right there, paragraph 53, is pretty much the entire meat of the complaint for all 5 allegations or all 5 counts of the complaint that we'll go into. So, paragraph 54. Furthermore, it is believed and therefore averred that defendant Moss was aware of the negative impact the false allegations would have on reputations of both plaintiffs Hadnagy and Social Engineer. On or about February 9th, 2022, defendants Moss and DEF CON subsequently authored and published a transparency report in which stated the following. We received multiple COC violations about a DEF CON village leader, Chris Hadnagy, of the SE village. After conversations with the reporting parties and Chris, we are confident the severity of the transgressions merits a ban from DEF CON. Defendant's publication of the aforementioned transparency report created a widespread firestorm of social media commentary. i.e. Twitter retweets and related posts, reacting to the news of plaintiff Hadnagy's alleged violations of the Code of Conduct. Speculation mounted as to what actions were taken by plaintiff Hadnagy to cause defendant Moss to abruptly terminate their long-standing business relationship with plaintiff Hadnagy's invaluable contributions to the event, meaning DEF CON. It is believed, and therefore averred, that due to the vague but troubling statements made by defendants, many have assumed that plaintiff Hadnagy perpetrated some sort of sexual assault and or sexual harassment, thus leading to the ban. Moreover, many have assumed that whatever plaintiff Hadnagy has been accused of must have been abhorrent, particularly because the event typically condones extreme and or unique behavior. And then jumping all the way down to paragraph 102, defendants knowing the truth, intentionally and or acting in reckless disregard as to the falsity of the matter they publicized, as well as the false light in which it placed both plaintiff Hadnagy and plaintiff social engineer, published a transparency report on February 9th, 2022, willfully and with malice. So paragraphs 102 and paragraphs 53 pretty much wrap up the majority of the actual complaint. Those are the meat and potatoes of what is being asserted here by Chris Hadnagy. The rest of it's kind of circumstantial, building upon facts to make these conclusions, to assert these conclusions and things. That's the end of what I'm interested in. There's some more. There's definitely stuff that we skipped over there in between paragraphs and paragraphs beyond. Those are what are most interesting. The big things to notice that between August 2021 and January, January 2022, when DEF CON gave a ban notice to Hadnagy, Hadnagy seems to be saying that they didn't discuss anything, and that would include, I would imagine, the alleged Code of Conduct violation DEF CON would later report in their transparency report in February. Another thing to notice is that Hadnagy is laying blame at DEF CON for social media or assuming or speculating that the issues which caused the ban to be issued involve sexual misconduct, including sexual assault and or sexual harassment. The complaint is that because DEF CON was so vague as to the reason of the ban, and because DEF CON tends to tolerate a lot of extreme or unique behavior, that just saying Code of Conduct violations means that people would automatically, and it could be understood and presumed that people would automatically speculate or assume some kind of sexual misconduct. And therefore, DEF CON is therefore responsible for defaming Hadnagy. That's going to be interesting to see if it gets a chance to play out in court. But it may not, depending on if the motion to dismiss from DEF CON coming in October is granted. In the complaint, you can see 5 distinct counts: defamation, intentional interference with contractual relations, tortious interference with contractual relations, invasion of privacy / false light, and intentional infliction of emotional distress. I am most familiar with defamation and intentional infliction of emotional distress, IIED. Invasion of privacy / false light, I'm not as sure. I'm not a lawyer. I'm not on this. I didn't research what all that means, and I'm not really paying attention to that count in here. From what I understand, if a lot of the things that underpin the defamation and intentional infliction of emotional distress also underpins that count, if those things aren't true, that count can't be true either. So, defamation and IIED have very high bars to overcome to prove your case. You have to prove that the facts that you've provided are true. You also have to prove that the defendant knew that what statement they were making was false. You have to also prove that the defendant's actions were malicious in their intent. And for IIED, I believe you have to specifically be intending to cause that person like emotional distress and harm. So there's a lot of things engaging on intent and what someone knew as regards to the falsity of something. Defamation, for instance, doesn't necessarily mean you knew it was false, but you acted with reckless disregard for the falsity of the claim. So maybe you didn't really do all that you could to ensure that it was true, or you didn't even do the bare minimum to ensure something was true. Like there's still like levels this is a very high bar, especially the IIED is very high, even higher than defamation, that I understand. But defamation IIED, there's a pretty high bar to get up to that. It's very hard to prove that. So that's already something that Chris Hadnagy is going to have trouble doing in court, is having to go over to up to that level of burden of proof. But I'm not a lawyer. I could be wrong. So discovery plans. So there was another document that was filed. So at some point, counsel from both sides and the people involved sat down. They basically laid out a bit of what each other has, what facts each other has, and what they're going to basically make as their cases, defenses, complaints in court, as well as then outlining what their discovery is going to look like. So they're kind of already agreeing to the scope of discovery and the scope to what this is going to look like and what each other's actions are going to look like going forward. This is an important part of the process because this means something could settle out. You're not wasting the court's time. Something could also be that, once there's something maybe during that meeting that was revealed that the plaintiff finally realized, well, heck, I don't have a case, and they drop it. So that was a possibility. It hasn't happened so far. But anyway, so they met. Then together they jointly filed, which means they both created a report that they both agree on, and they have submitted that to the court. So that was submitted on September 7th, 2022. It's down to the doobly-doo. It does not have paragraph markings, so I'm terribly sorry, but you can use word search to figure out where I'm looking. I will try to quote and end quote each of those quotations. Here is what Hadnagy's report on the complaint says in part. This ban on plaintiff's attendance, contribution, and participation was based on alleged violation of Defendant DEFCON's Code of Conduct and effectively excluded plaintiffs from the event indefinitely. Defendants provided no evidentiary support or explanation regarding their abrupt termination of plaintiffs' participation at the event. Further down, it is believed and therefore averred that these others included a disgruntled former employee of plaintiffs who played a key role in the orchestration of plaintiffs' takedown. So, and then it goes on a little further. So they're referencing that during this discussion they had with the lawyers that they found that there were some facts that DEFCON's going to have in their defense here, that there were multiple people that came forward with complaints, reports of violation. There's a third party involved who was working on behalf of a potential victim, and there were a half dozen others that's quoted as also. So that's what these others mean, and they have specifically identified what Hadnagy's team labels as a disgruntled former employee of the plaintiffs. Here's what DEFCON reported as to the complaint. This is kind of their defense. In late 2021, an ex-employee of Plaintiff's Social Engineer LLC, Social Engineer, approached Defendant DEFCON through a third party. The ex-employee described to the third party a campaign of abusive, harassing, and controlling behavior by Plaintiff Chris Hadnagy, precipitated by her decision to leave Social Engineer. The third party reached out to Plaintiff Hadnagy, who corroborated to the ex-employee's assertions in key respects, but offered post hoc and factually unsatisfactory explanations for his conduct. The defendant DEFCON then connected with at least half a dozen other members of the hacking community who described similar inappropriate conduct by Plaintiff Hadnagy. Plaintiff Hadnagy's misconduct gravely concerned defendant DEFCON, especially since, among other things, Plaintiff Hadnagy had personally confirmed the ex-employee's allegations. Defendant DEFCON took seriously and continues to take seriously its position as the host of the preeminent event in the hacking industry. The defendant DEFCON did not want to provide a platform to an individual engaging in the kind of behavior which Plaintiff Hadnagy had admittedly and unapologetically engaged. Accordingly, on February 9th, 2022, Defendant DEFCON released the following statement announcing Plaintiff Hadnagy's ban from subsequent DEFCON conferences, which constitutes the entirety of the alleged defamation in this case. we received multiple code of conduct violation reports about a DEF CON village leader, Chris Hadnagy of the SE Village. After conversations with reporting parties and Chris, we are confident the severity of the transgressions merits a ban from DEF CON. The statement above is true, and a discovery and motion practice will demonstrate cannot support plaintiff's defamation-related and tortious interference-related causes of action. So it's interesting to note that DEF CON is asserting that Hadnagy corroborated the allegations against him to a third party. So it would seem that Hadnagy agrees that he was involved in the conduct being alleged, but doesn't believe it amounts to misconduct or provides reasons for the conduct he believes doesn't make it wrong or a code of conduct violation. And DEF CON obviously disagrees with whatever characterizations Hadnagy made about his conduct. Also interesting to note that it was especially because Chris had confirmed the allegations' validity, they went and asked several more community members and found there were more than just one ex-employee of Hadnagy's who could recount inappropriate conduct. And that's the reason for the ban, especially because Hadnagy corroborated the key respects of the alleged conduct. Discovery gets a little interesting too, because originally Hadnagy said he had no desire to publicly expose the identity of the accuser, yet in Discovery, the plan for it, he appears to demand just that. Quote, plaintiffs intend to conduct written discovery on the following issues: information and documentation pertaining to the alleged COC violations, including but not limited to instances of alleged harassment that led to plaintiff's ban from the event, i.e. defendant's allegation that they are insulated from liability as truth is their defense, identities of all and any and all fact witnesses with information regarding the alleged COC violations that led to plaintiff's ban from the event so that related or relevant deposition testimony can be conducted, end quote. Fact witnesses would have to include, I would think, the third party as well as the victim in this case. And assuming the other half dozen people who DEF CON consulted with are potential victims as well, they would be victims as well. DEF CON then responds to the complaint and addresses venue as well as jurisdiction of the East District of Pennsylvania. But skipping past that to the counts of the complaint, DEF CON says this, quote, even if the court moves beyond the threshold issues, plaintiff's claim still fails because 1, every part of the allegedly defamatory statement is true. 2, plaintiff's tortious interference claim lacks merit because, among other reasons, defendant lacked any intent to interfere with any of plaintiff's contracts, and any interference with plaintiff contracts were not improper. And 3, even accepting plaintiff's allegations as true, no reasonable fact finder could conclude that defendant's conduct meets the extremely high bar in Pennsylvania for intentional infliction of emotional distress, end quote. This is why I said both parties can't be telling the truth. So really we get down to inconsistencies here in statements. Hadnagy says he never spoke to DEF CON, or rather DEF CON never spoke to him. They never spoke to each other. That part may be true, but the allegation of Hadnagy that he is unaware of the situation surrounding the allegations or the allegations themselves is rather fishy at best. Between August 2021 and 2022, he should have been able to recall those conversations he had with the third party, the ones where DEF CON says he corroborated the key parts of the allegations. That's, of course, assuming DEF CON's facts about the third party are correct. Hadnagy said he has no desire to know the identity of the accuser, but yet has signaled his demand to know it via discovery. This doesn't paint Hadnagy as a good faith actor, but the first statement was not made in court, by the way. So that's probably not going to have much legal bearing at this point. It may have something if it goes to a jury trial or even just a judge trial. It may paint him as not necessarily a good faith actor, but it may ruin some credibility in a jury trial. But that's speculation. I'm not a trial attorney. I'm not sure. Definitely, it's definitely not looking good. DEF CON says they have the receipts. In the discovery plan report, DEF CON is almost saying, here's what you're going to discover, that you admitted to misconduct, and that's a big reason why we banned you. If it's true, I don't see how this doesn't get dismissed after discovery, especially. There is also a small discrepancy with what DEF CON is reporting. DEF CON reported, I've read it probably 3 or 4 different times throughout this. DEF CON said they spoke with a third party and Chris in their transparency report. But when DEF CON's statements here, they said they spoke to the third party. The third party spoke to Chris. Again, the statement in the transparency report is a statement made outside of a court, so it's hearsay. But when we're taking a look at what they're saying in the statements, it doesn't quite match up. It's not that big of a problem, because you got to think when you're DEF CON and you're a conference, you don't want to necessarily say someone else was involved in this. The third party at that point, from their perspective, they were representing maybe that third party as part of them. And maybe that's what's going on here. I don't know. But there's a small discrepancy there. Is it that big? Is it not? I don't know. Who knows what that will be? Personally, it doesn't look that big of a discrepancy, but who knows? The other interesting thing, and one that I actually didn't script, so I'm going to go a little off script here. I'm sorry. The other part that I didn't mention was that that, and this has to go to the two other allegations, or rather complaints, the counts. Intentionally interrupting with contract and business relationships, basically. The idea was that Chris is alleging that DEF CON essentially was trying to get rid of SE Village and replace it with something similar with someone who was his ex-employee. So he's trying, his framing of this is, there's an ex-employee of mine who's disgruntled, went and complained to DEF CON in an attempt to try and get them to kick me out and put their village in. That's the short and gist of that little thing there. So a little conspiracy here that's going on. Whether it's a theory or a fact, that's still yet to be determined. But that's what's going on there. Whereas DEF CON is, of course, saying, no, this person went to a third party who came to us. They then went further and talked with Chris, assuming that's true. And Chris said that, yeah, all of those things happened, but for reasons they're not misconduct or against the code of conduct. Again, assuming all of that is true, which they could not be. We'll discuss that here in a bit. So here's why I hope this gets dismissed. Codes of conduct. Codes of conduct are an important tool and safety mechanism for participants of conferences. It makes clear what inappropriate conduct looks like. It makes clear what will happen if you violate it. And it makes clear how you can report inappropriate conduct. The idea is to make people feel safe, and if something does happen, they can have confidence that they can bring the matter to the conference leadership, and they will investigate and act appropriately to protect the community if they have to. This defamation case on its own, and honestly any defamation case like this on its own, chills the codes of conduct conferences have worked for years with the community and victims to build and enforce. I wouldn't blame a victim or someone afraid of becoming a victim, possibly marginalized people, for not wanting to go to conferences now, because the person they end up having to report on will end up suing the conference for defamation just to find out their identity, which in and of itself is re-victimizing a victim. Which I'm not alleging that Chris has done it specifically to do that. Let's make that very clear. I am saying there is an inconsistency between what is in court documents and what he stated outright in his public statements. There is a difference between those to be highlighted. But this could be used by other people to do that very thing, even if it's not Chris's intention. I hope there's a way that DEF CON can provide their receipts suitable to the court during their motion to dismiss, such that the judge has to ask the plaintiff if those are really his messages and statements, and does he realize that they seem to corroborate allegations of misconduct, that DEF CON would reasonably then have a cause to issue a ban and issue the statement they did, thereby making defamation impossible, and I would imagine also pretty much the rest of the allegations or the counts. Because if Chris Hadnagy persists in claiming there's no misconduct and that DEF CON has no evidence for this, the discovery is only going to prove the case was frivolous to begin with, and was used to get at the victims, which I would hope DEF CON could convince the court in that situation to issue sanctions or other types of penalties to Hadnagy and his attorneys. Again, all assuming that DEF CON's telling the truth here. Keep in mind, for the initial complaint, Hadnagy as well as his attorneys signed statements swearing that the facts they presented are true. They cannot be if DEF CON is telling the truth in their report here. DEF CON had to do the same thing too. They can't be true if what Chris has alleged turns out to be true. If this case is dismissed, it could be a big success for codes of conduct, actually. It would prove to the community that these work, and that people who violate them will not prevail in these courtly shenanigans. And again, that's assuming DEF CON is telling the truth here. In order for Chris Hadnagy to be correct, there has to be gross corruption within the DEF CON at multiple levels. One of the things that Chris Hadnagy is accusing of Jeff Moss / DEF CON is that they are the same person, meaning that there is not sufficient infrastructure, there is not sufficient leadership, or exercises of leadership as far as like meetings and meetings of members and leadership, people who would quote own the company, to essentially insulate Jeff Moss as someone who could be considered synonymous with DEF CON. You can read that in many of the paragraphs I didn't read. You can read his arguments as to why that's the case. Is he correct? I don't know. I mean, that would mean there's corruption at DEF CON on multiple levels. No person and no organization is perfect, but is it likely to be true of DEF CON? That's going to have to be up to you and me personally until we find out more in October when the motion is dismissed and submitted. If this case goes to discovery, it will potentially harm victims. Again, if DEF CON's assertions are true. If this doesn't go to summary judgment, as DEF CON has indicated it will pursue, then it will erode a lot of trust participants have in being able to be safe at conferences. The worst thing is that if DEF CON statements turn out to be true and this goes to discovery, or worse, to a proper trial, then every abuser in the community will be emboldened to act. Because if one person can bring such a suit against a large conference, then all an abuser has to do is to do the same thing. Do the same if they're called out and watch smaller conferences die under the weight of illegal and financial ruin. All because the conferences wanted to ensure their con-goers' safety. If DEF CON's telling the truth, it seems they went through a lot of work to investigate the matter. Unlike many people's characterizations of code of conduct, it's not the fact that someone can just make an accusation, hide behind anonymity, and expect anyone they want to be banned from the con without further investigation. It's simply not how it works. However, if Chris Hadnagy's correct, then the thing that a lot of us have been shouting down, this very accusation against code of conduct, turns out to have been true, if Chris Hadnagy is correct. So that's a consequence on that side. Again, trying to look at this in lights favorable to both sides here, because they can't both be true. So what would be the consequences in both situations? Victims do need to be believed. That's regardless of this case. Conferences need to be able to investigate a complaint. Complaints also have to have details that can be corroborated. They have to be specific enough to investigate too. It's my fear that if DEF CON is telling the truth and this goes to trial, we will see an increase in instances of misconduct or abuse at conferences, especially that go unreported. Again, I have been very careful to make sure I don't enter into allegations myself in this video. I am discussing facts and assertions, or versions, of both parties, and try to look at lights most favorable to both. The information I have presented is from public statements made by DEF CON and Hadnagy, as well as the court documents, which you can again get down in the doobly-doo. I have been careful to include the items and maintain characterization as they were presented as much as possible. Again, I'm not a lawyer. This is not competent legal analysis or legal advice to anybody. This is just me reading court records and giving my thoughts on the implications of the complaints, the assertions process, and what will happen in either case of one being true over the other. So what are your thoughts? I don't really care about your thoughts about whether you think Chris Hadnagy did something, whatever he did. I'm not interested in your thoughts as if DEF CON's a corrupt organization. That's not what I'm interested in. I'm interested in what do you think about codes of conduct? What do you think about cases like these? What are the consequences you'll foresee if one is true versus the other? Leave that down in the description and find me on social media and connect with me on there. I'll see you in the next one.